Recent news about the completed merger between Compass Real Estate and Anywhere Real Estate has sparked a broader conversation about real estate brokerage consolidation, market concentration, and how these large transactions are reviewed from an antitrust standpoint. For most people, that may sound like an industry business story. But for fiduciaries and estate attorneys, I think it raises a much more practical question. How do you make sure a fiduciary property is marketed through an open, competitive, and defensible sales process? My name is Andrew De Vries. I'm with Probate Agent Real Estate Services and Berkshire Hathaway Home Services. For more than 20 years, I've specialized in helping fiduciaries navigate fiduciary real estate sales throughout the San Francisco Bay Area. One of the fundamental objectives of any fiduciary real estate sale is not simply finding a buyer. The objective is creating the broadest possible marketplace for the property. Why? Because competition benefits beneficiaries. Competition helps establish fair market value. Competition helps fiduciaries demonstrate that they took reasonable steps to maximize the value for the estate or the trust. Competition also helps demonstrate that the transaction was conducted at arm's length and that the fiduciary took steps to avoid actual or perceived conflicts of interest. And competition helps create a record that can withstand future scrutiny. As brokerage consolidation increases, fiduciaries may wish to pay even closer attention to how their properties are being marketed and whether the sales process is designed to encourage the broadest possible buyer participation. This is particularly important because fiduciary sales are often reviewed long after the closing. Beneficiaries, attorneys, successor fiduciaries, courts, and even opposing counsel may eventually ask questions such as, how was the property exposed to the market? How was the value established? How were offers solicited and reviewed? How can the fiduciary demonstrate that the property received maximum market exposure? How can the fiduciary demonstrate that all qualified buyers had an opportunity to compete? How can the fiduciary demonstrate that the transaction was conducted at arm's length? And perhaps most importantly, how can the fiduciary demonstrate that the process was designed to maximize competition among buyers? These questions become especially relevant when a transaction involves dual agency, in-house buyers, affiliated relationships, or any circumstance that could create actual or perceived conflicts of interest. Now, to be clear, many of these arrangements may be fully legal and properly disclosed. However, fiduciaries should remember that legality and defensibility are not always the same thing. The question is not simply whether a transaction complied with the law. The question is whether the fiduciary can clearly demonstrate that every decision was made solely in the best interest of the beneficiaries. As fiduciaries know, beneficiaries do not evaluate transactions only through the lens of legality. They often evaluate them through the lens of fairness. When a beneficiary sees a transaction involving dual agency, a buyer represented by the listing broker, or a brokerage that controls a significant share of any local market, questions may naturally arise, even if the transaction itself was entirely proper. In some cases, these questions may come years after the sale has closed. The fiduciary's responsibility is not only to achieve a good outcome, their responsibility is to create a process that can withstand scrutiny if those questions are ever asked. For that reason, I believe several best practices are worth considering. First, ensure broad and comprehensive market exposure. Second, obtain independent and well-supported valuation guidance. Third, create a transparent offer review process. Fourth, carefully evaluate any actual or perceived conflicts of interest. Fifth, document every significant decision throughout the transaction. And sixth, ask whether the sales process is truly designed to maximize buyer competition and support an arm's length transaction. In my own fiduciary real estate practice, I have long believed that the safest approach is one that maximizes competition, transparency, and independence throughout the sales process. It is also one of the reasons I have historically avoided double-ending fiduciary transactions. I believe fiduciaries are best served when buyers compete openly, negotiations remain independent, and the sales process is as transparent and defensible as possible. The fiduciary's duty is not to maximize the market share of any brokerage. The fiduciary's duty is to maximize value for the beneficiaries. And in fiduciary real estate, market competition matters more than market share. As the real estate industry continues to evolve and consolidate, I believe that distinction will become increasingly important. If you're navigating a fiduciary real estate sale, I invite you to subscribe to this channel. I regularly share educational content focused on fiduciary real estate best practices, risk management, valuation, property preparation, marketing strategies, and helping fiduciaries protect beneficiary interests throughout the sales process. If you're currently dealing with a fiduciary real estate matter and would like to discuss your situation, please feel free to contact me directly for a confidential consultation. My goal is to help fiduciaries make informed decisions, minimize risk, and maximize value for the beneficiaries they serve. If you found this video helpful, please subscribe, like the video, and share it with a colleague or professional who works with fiduciaries. And if there is a fiduciary real estate topic you would like me to cover in a future video, please leave a comment below. I'm Andrew De Vries with Probate Agent Real Estate Services and Berkshire Hathaway Home Services. Thank you for watching, and I'll see you in the next video.